Hi everyone, welcome back. Brian O'Donnell here, OG Private Wealth. And today I'm really excited to have Doug Lodmell from Lodmell & Lodmell, one of the leading experts on asset protection. One of the things that we pride ourselves on at OG Private Wealth is not just handling the investments, but looking at the big picture, looking at the other areas of wealth management that we think are critically important. And one of those areas has to do with asset protection. So without any further ado, I want to welcome in Doug. We have a presentation to walk through with you and just sort of some concepts that he uses to help his clients protect their assets. Hi, Doug.
Hey, Ryan. Hi. Thanks for having me.
Yeah, you're welcome.
Yeah. Yeah, so asset protection is becoming an integral part of financial planning, estate planning. It's 23 years ago when I started this, no one even knew what I did. Asset protection. What are you, a security guard? And but today it is fundamental, and most everybody understands what it refers to. What they don't understand is what it actually means. So my goal for this presentation for your clients is really, by the end of this, they should have a really clear understanding of what asset protection is and the major tools that we use to actually make it happen.
That's great, Doug. I think I think a lot of people have this perception that it's really only useful if you have 10, 20, 30, 40, 50 million dollars or $1 billion to
Right.
utilize some of these strategies. But you and I have talked a lot about it is a lot more for the millionaire next door, if you will.
It really is. I mean, if I look at my clients, my average net worth is somewhere around $3 or $4 million
Wow.
for my clients, because somebody who's worked really hard, they're a professional or they're a small business owner, they've built up that $3 or $4 million over a 30 or 40-year career. They can afford to retire in the lifestyle that they are used to. They really don't have to worry about anything, but they can't afford to lose any of it. And they certainly are not prepared to deal with a lawsuit. It throws them completely off their game. It causes their businesses to suffer, and just the risk of a major loss. It can impact their ability to retire when they expect to retire. So yeah, that's the person that I find actually has the most benefit from asset protection. Certainly the client with $20 million or $50 million benefits as well, but
Sure.
often we're doing it a little bit different for them. We're kind of nest egging approach, whereas with the $3 or $4 or $5 million client, we're really putting everything in there. We really want to protect it all.
That's great. Well, I'm looking forward to what you have here.
Yeah, okay, so just a little bit about who I am. I'm an attorney, been practicing for 23 years. I have an LLM in taxation, which means I somehow decided going to extra law school would be a good idea. So an extra year of nothing but tax code stuff. That really helped me, though, when I developed some of the tools in here, as we'll talk about. So I have also written a book called The Hijacking of Justice in America, The Lawsuit Lottery, because that's the way I see it. I mean, after practicing in this area and clerking for a federal district court judge when I was in law school, it's a lawsuit lottery. The plaintiffs' attorneys have figured out how to just use the legal system to create a redistribution of wealth, without necessarily any regard to fault or blame. It's just, how can I use the legal system to extort money? So my whole goal is to undo that for my clients, to re-level the playing field, so to speak. So that's what we'll talk about. So the first question I always want to start with is, well, what the heck is asset protection? And to keep it real simple, it's just taking your assets and creating a barrier around them so that a potential creditor can't reach them. That's it. So if someone doesn't have any assets, let's say somebody who's just out of school, they got nothing but debt, they don't need asset protection because there's nothing to take. But as you build your wealth, as you become more successful and you pay off that debt, now that you're saving, that's when the switch flips, and all of a sudden, they want to protect assets. They're thinking about, losing becomes a more important concern than even gaining more. And so I noticed that with my clients, and it just happens at a certain stage in their career. So that's what I look for, is when has the client realized that asset protection is really a critical thing. Is it necessary in this country? I mean, I hardly think this slide is even needed. We all know the way our legal system works. I mean, 40 million lawsuits are filed in the US each year. The plaintiff's bar, the plaintiff's attorneys, the billboards in every major city. Have you gotten injured? Are you sued? Did you get sick on a cruise? Now I see this is crazy, but the coronavirus lawsuits are coming.
Sure.
I just saw a continuing legal education for plaintiff's attorneys, how to sue for coronavirus. I mean, just watch, mark my words, watch the corona lawsuits come rolling in. It's
Yeah,
going to be
I would say this concept of asset protection is one of those that, you know, people are always so curious, especially my clients. I mean, just being the litigious society that we live in nowadays, you
yeah.
know, and people, and we set up LLCs in different structures, but there's, you know, it's always that what's missing. I think what you have to offer is that missing piece.
Right. Yeah, and it is. It's missing for most people because it's still a new area of law. And when I say new, about 40 years old now. So that's new in the legal world. And a lot of people still don't know about it. It's the people up front, people like you who understand it, who've looked into it for themselves, who go, oh, you know what? This is something my clients really need to understand. So you can see the other points on the slide. It's just, you know, we live in a society where I don't think there's any real doubt that if you have assets, you need to protect them. So what is it that an asset protection plan needs to accomplish? Well, in my book, there's 4 things. It needs to work. In other words, it's just got to be effective. You can't have a fake plan. And I bring that up because there are a lot of fake plans out there. They literally are. They're not designed to work. They're just, it's like, remember when you could buy a sticker for your house saying this house is secure with, you know, it has a
Sure.
monitoring system. There was no monitoring system. It was just a sticker. There's a lot of asset protection plans that are just stickers. My clients want to have control of their assets. They want to keep control of their assets as long as practically possible. They want the cost to be reasonable, and they want the compliance, meaning how much work is this going to cause for my CPA, how many tax returns, you know, what kind of compliance documents. They want that to be minimal. It's unlikely that it's zero, but they definitely don't want it to be extremely complicated. So everything we look at here, I'm going to keep going back to these 4 things and say, okay, how does this compare when we look at our 4 goals?
Okay.
So there are 3 big tools. The first is called a limited liability company. I'm guessing most people know what this is. Most people either have one, they certainly see them. Virtually every business out there today is organized as an LLC. So we'll talk about that. The second is an asset management limited partnership. And it's similar to an LLC, but a little bit different. So we'll talk about that. And then the last is the asset protection trust. And that's the one that most people just have no real understanding of. And when I say most people, I mean even professionals, even attorneys. And I work with attorneys all through the country to help them add asset protection to their practice. And I can tell you, the asset protection trust is a mystery to most people. By the end of this webinar, you're actually going to know more about asset protection trust than most attorneys out there. So you're going to be very educated.
Great.
So the limited liability company, it's a simple tool. It limits liability. It wraps it up. We use this to put in risky assets. So if you have a real estate portfolio, investment real estate, rental properties, an office building, whatever it is, that's the kind of asset that would go in an LLC. We can segregate those assets one from another. So let's say you have more than one investment piece of real estate and they all have quite a bit of equity. Well, we can do more than one LLC so that you end up with a mold claim on one property. It doesn't infect the other property because they're all in the same LLC. And then the way it works is it has charging order protection. So LLCs, if a member of an LLC gets a judgment against them, that judgment doesn't automatically attach to the LLC, and that judgment holder can't go in and foreclose on that interest and get the assets. The best they can do is get a charge against the interest of the member. So that's really how asset protection starts with LLCs, is charging order protection. The second tool is the asset management limited partnership. It's very similar to an LLC. It also has charging order protection. That's how it works. The difference is now we're going to use a state that is probably not your home state, unless you live in Arizona, because Arizona is the state that really I prefer when we're talking about this entity. It is your holding company. It's going to be at the center of your plan, and it's going to be where you consolidate your assets. So if you have a brokerage account, it's going to go into the asset management limited partnership, and that has a separate tax ID number. files a separate tax return. It's a pass-through entity, so the tax return is still going to spit K1s off to you individually. There's no additional tax. There's no corporate tax rate for it. It's very simple. But it's a way you can add family members. Arizona has great charging order protection, so it's a really good state. And that's where we're going to also hold the LLC interest. So let's say you have 4 LLCs for investment property, and maybe you even have an airplane, put that in an LLC. Those LLCs in turn would be owned by your asset management limited partnership, your holding company. And if you want, for some clients, it's important, they actually want a little privacy around their assets. In other words, they don't want anyone to be able to look up who owns these entities. We can add that as well. And we do that by adding a Wyoming LLC as the general partner of that asset management limited partnership. So now we get on to what we're really going to spend the rest of the time on, which is the asset protection trust. So the asset protection trust is what's called a self-settled spendthrift trust. It's designed to sit on top of the limited partnership. So it's going to own the majority interest in that holding company. The protections it provides are not limited to any specific type of risk. It can additionally add privacy, and it solves the charging order being your only remedy. So we actually make the charging order the first layer that they have to get through, and then the trust becomes the second layer. So it adds dramatically to the asset protection. And I'll show you exactly how that all works. So what is an asset protection trust? Well, I said it. It's a self-settled spendthrift trust. Self-settled means that you're creating it for yourself. So a revocable living trust that most people have for estate planning is also a self-settled trust. It's a self-settled spendthrift trust. The asset protection trust is distinct because now we're adding spendthrift provisions. And what those are provisions which specifically limit a creditor of yours from accessing the assets of the trust. And that's what makes it an asset protection trust versus a revocable living trust, which is not asset protection. It's also irrevocable. That's important because if it's revocable, there's no asset protection. If it's irrevocable, there can be, depending on how it's set up. So there's 2 schools of thought on how this is done. You can do it internationally or you can do it domestically. So the international option was first. It was created in 1984 by the Cook Islands Trust Act. Cook Islands is a jurisdiction way down in the South Pacific, English common law, English speaking, New Zealand passports, but it's a separate and distinct jurisdiction. So they created a statute and said, well, we'd like to bring some business down here. We really don't have anything but black pearls and tourism. And so we would like a financial industry, and we're not going to become a tax haven. So what else could we do? So they created a statute that really was unique in the world. And what it allowed for is the actual creation of a self-settled spendthrift trust, and made it incredibly difficult for someone to sue and break into one of those trusts. So some of the challenges and hurdles that you have if you try to break into a Cook Islands trust are the Cook Islands has a statutory non-recognition of any other jurisdiction's court orders or judicial proceedings. In other words, you bring a judgment from the United States down to the Cook Islands, it's worth 0. You have to start your case all over again from scratch. You have to prove your case beyond a reasonable doubt, the murder standard, which is incredibly difficult to do, and in a civil case is unheard of. There's no contingent fees allowed, so you're not going to get a free attorney down there. Anyway, which attorney is going to want to take a case that they have to prove beyond a reasonable doubt?
Right.
So you're going to be paying out of your pocket to try to sue. You can't amend your claim once you file it, so there's no fishing expeditions. Get down there, figure it out, get depositions, discovery, and then change your whole story. That doesn't happen down there. And if you lose, or more likely when you lose, you're going to have to pay the legal fees and costs of the winner. So there's a financial risk of you going down there and trying to pursue a trust. And to cap it all off, by the time you ever figure this out, you're probably barred from even trying by the statute of limitations, which is very short down there. So, you know, the net is that we've had these trusts now for 35 plus years, and we have case law, and they have proven to be incredibly strong.
Yeah, I
Incredibly
remember seeing an article, I think in the New York Times, after IRS trying to go after certain people's trusts down and specifically citing the Cook Islands.
Yeah, yeah, there's quite a bit of case law, and anybody interested, I'll give you, well, the website's right there on the slide, assetprotectioncouncil.com.
Okay.
If you go to that website and you click the resources tab and then you click the case summaries, I've briefed pretty much every major case that has to do with asset protection. So you can actually read them yourself and see how the Cook Islands has performed in these cases. And yeah, I wouldn't want to be suing and trying to break into a Cook Islands trust. And I know pretty much most everything there is to know about that jurisdiction. So if I wouldn't want to do it, I don't think some attorney here that is real happy with their judgment all of a sudden finds out, oh, well, we'll just pursue it down there. It doesn't really happen.
Great.
So that's the good news, Brian. I mean, you know, if we look at it on our 4 criteria, effectiveness in spades. I mean, it is effective. It is incredibly effective. The other issues, not so much, right? If you're going to use a Cook Islands trust, you need to have a Cook Islands trust company, and they're going to be in control of the trust, and you will not be in control of the trust. So control is a downside. Cost, it's definitely more expensive to do a Cook Islands trust, both to set up as well as to maintain annually. You know, we're talking anywhere from $30,000 to $100,000 to set up this kind of trust, and I tell clients to budget $10,000 a year to maintain this trust. And that includes your accounting fees, because there's also now compliance related to that trust. You have to file Form 3520 and 3520A each year. It's a full balance sheet disclosure of the trust assets, all the parties to the trust, sometimes can even include a copy of the trust. So not really exciting to do for most clients. So for that reason, you know, Cook Islands trusts, as strong as they are, you don't see them in use as much as you might think because of these downsides, these costs. So let's flip to the domestic side. In 1998, Alaska saw the popularity of the Cook Islands Trust, which had been around for almost 15 years at that point, and said, why are we letting all this business go down to the Cook Islands? Alaska's practically a separate country. Why don't we just create a statute? And they did. And they copied and modeled the Cook Islands statute as much as they could. And you know, once Alaska did it, Nevada and Delaware and Wyoming, all the other, you know, usual suspect states jumped on board and said, hey, us too, we think this is a great idea. And so today we actually have 19 states that have some type of domestic asset protection trust legislation, which is really pretty amazing if you look at it. I mean, in other words, you know, more than a third of the states think this is a great idea to protect your assets. So I remember way back in the beginning, some attorneys were saying this isn't valid. No U.S. court is going to recognize a self-settled spendthrift trust. Now that argument is pretty much wiped out, because now we have 19 U.S. states that, and more every day.
Wow.
Yeah. So so that's good. That's good news. So what are the advantages of a domestic asset protection trust? They're less expensive. You're going to use a domestic jurisdiction. So while it may not be familiar to you, at least it's not strange, right? Nevada is not familiar maybe to you if you live in California, but it's not strange either. You could get comfortable with a trust company there. And compliance is another issue. Since it's not foreign, it does not have to file the foreign trust compliance, which is that 3520 and 3520A. So it's a lot easier to do. What are the downsides? Well, unfortunately, the downside is effectiveness. It just doesn't have the same predictability as the Cook Islands Trust. When you're talking about a domestic asset protection trust, we now have case law, and it's pretty much all bad, right up to and including last year. So we continue to have cases and they continue to fail. So I don't feel super comfortable domestically, even though the costs are lower and it's more comfortable for clients. They just don't work. They're not and in my job, you want to be predictable, just like in your job. You want to be as predictable as possible, right? I mean, you can't predict everything, but you can be as good as you can, and the better you are, the happier your clients are. The same is true for me. I want to be able to say with confidence this is really going to work. And I don't feel I can do that with a domestic asset protection trust.
Yeah, I feel like if you're setting up, you know, something, going through the process of setting this up, and you're protecting against that 1 or 2% chance of something bad happening, you want to be pretty darn certain it's going to hold up.
Well,
if you're going through this whole process.
yeah, that's exactly right. And you're right. Maybe it's just a 1 or 2% chance that we're going to have to use this. But why then throw in a big question mark in that 1 or 2% that now there's a 50-50 chance your asset protection is going to work.
Right.
That doesn't make sense.
Right.
That's a big strike for me. That's pretty much a fatal strike. The other issue is control. Let's say you even thought the domestic trust was a good idea. You cannot have any control whatsoever. You need to be way far away from that right from the get-go. So that's even harder for clients to deal with, because now you're asking them to give up control right away, and in a plan that maybe is going to work. So what are our options? Well, I looked at this when I first started practicing law 23 years ago and said, clearly the offshore is the right answer for protection. At the time, there was no domestic option. I actually started practicing law before there was a statute in Alaska. And so I looked at it and said, well, why can't we? And this is a benefit of that tax training I got in my tax program at NYU. Can I make a domestic trust out of an international trust? In other words, can't I make it domestic for tax purposes? And the answer is yeah. There's a very simple 2-part test that the IRS lays out very clearly that determines whether a trust is considered domestic or foreign. And it has nothing to do with where the trust is registered. All it has to do with is who has primary supervision and control over the trust, what jurisdiction, and what person. That's it. So I said, well, let's just meet that test. So what I created is something I call the bridge trust. It's a foreign asset protection trust, but it's brought across the bridge and turned into a domestic trust for tax purposes. So we get all the simplicity of a domestic grantor trust, just like a revocable living trust. Nothing from a tax perspective complicated at all. It's disregarded for tax purposes. It's very simple. But for asset protection purposes, it's a foreign asset protection trust. The other thing I did is I said, well, I don't really need the foreign trustee in control of that trust now, and probably never, but even if we do, it's going to be in that 1 or 2% of the time that we have to use the trust. So why don't we put them in a standby role instead of in an active role? And do they really need to charge their whole fee if they're in a standby role? Well, I was able to negotiate that they don't. They're willing to charge a highly reduced fee to just be in a standby role. So what we end up with is offshore protection, but with domestic simplicity. So there is no IRS Form 3520 or 3520A, those complicated forms that have to be filed every year for foreign trusts. There's no FinCEN or FACTA disclosures for foreign accounts. We don't have to open up an account in Switzerland and send our clients money offshore. It can stay right with you, stay right where they're used to having it, invest it the way they've always invested it. There's no IRS filing requirements for the trust at all, unless we have to cross the bridge. And again, if we have to cross the bridge, that means that the world is falling apart for our client. That's a different story. We're willing to take those costs and say now they're worth it. But prior to that, and for most of my clients for their entire life, there is no tax return and no filing requirements.
Sure.
All your assets can stay right where they are. We don't have to have a foreign trustee in actual control of anything. You, the client, can be the trustee of that trust, the bridge trust. So your control element is satisfied. You can stay in control. And from a tax perspective, it's a domestic tax neutral grantor trust. So very simple. When I first started doing this, again, it was kind of like asset protection as a whole. A lot of attorneys were confused, thinking, wow, you're kind of breaking some rules here about what we think is an asset protection trust. Well, now 23 years later and 3,500 of these trusts later, with over 100 triggered and had to go offshore, we've proven that this works incredibly well. It works as well as the foreign trust because really it is a foreign trust. We're just making it simpler until we need to use it. So if we compare the bridge trust with our 4 criteria, is it effective? Absolutely, because it becomes a foreign trust and it's just as effective as a foreign trust. Control, you get to keep control, the client as the trustee of the trust, right up until the moment that we ever have to use it. Cost, it's less expensive than a foreign trust by far, and particularly in the annual maintenance. It's much easier to maintain a bridge trust. And compliance, there's none at all. No 3520, no tax return. So we really meet the test with flying colors as far as what clients want. with effectiveness being the driver. In other words, it's not a fake sticker on your window that you have a home security system. It's a real foreign asset protection trust if we ever have to use it. So I don't know about you, but I'm pretty visual. So I like to kind of put it all together. So looking at this from a visual standpoint, the asset management limited partnership is your centerpiece. That's your holding company. What's going to go in there is your LLCs, right? So those little houses are your LLCs. One has a house, one has a boat, one has an airplane. We can have as many of those as make sense for you. The bridge trust is there, and then you still use your revocable living trust. It's still going to be effective and still going to be relevant for your death. And what goes in the asset management limited partnership? Well, of course, all the LLCs, also cash, stocks, bonds, collectibles, securitized assets, cryptocurrency, whatever you can think of that doesn't have risk. In other words, those already risk-free assets, investments in other LPs, etc. Who controls it? You control it. You're the general partner. So you have direct control of all those assets. So you manage the accounts, you talk to your stockbroker, you manage everything. Who owns it? The bridge trust owns it. The bridge trust is going to be the 98, 99% limited partner. So it's going to have the lion's share of the ownership. We want that because that's where we want the assets to go in case of a trouble. If there's no trouble, right, then all of the assets are going to pass through the revocable living trust. It's going to do all the things that a revocable living trust should do. It's going to distribute your assets. It's going to maximize your estate tax exemptions. You're going to avoid probate, smoothly pass your assets to your heirs. That's what RLTs are supposed to do. If, on the other hand, we have a threat, then the assets are going to pass and be distributed directly to the bridge trust. And at that point, the bridge trust can take steps necessary to protect those assets, including moving them offshore if that's what's going to protect them. And that's pretty much it, Brian. To keep it simple, I probably brought up some questions for your clients, and maybe you even have some that you think they might ask that you can ask for them.
Well, I think, one question, I think you and I'd had this conversation, creating the structure like this for your assets.
Yeah.
Restructuring in a way that you're certain that if push comes to shove, you get sued for some judgment, your lifestyle is not going to change. And it's almost like a game of poker where, if someone does come to sue you, you're set up in a way that if you need to pull the trigger and move everything offshore, protect all your assets, you can, but hopefully you don't. And just having things structured in such a way will likely to deter, frivolous lawsuits or something that may not go forward.
Yeah, it's huge. And that's a really good point because, I have a lot of clients that call me and go, Doug, we have to trigger the trust. And I say, okay, what's up? And they'll say, well, my main employee walked out and she was really upset and she said, I'm going to get you. And, I know she knows where all the bodies are buried and she's been with me for 20 years and I'm a little worried I'm going to get sued. That's not the moment to trigger the trust because one, you don't know if that threat's really real, if it's actually going to materialize into something. Or we have, somebody says, I got a demand letter over something, and I think we need to trigger the trust. The answer is we're not triggering the trust till we're way later in the game. Till usually there's already a lawsuit filed, we've already gone through depositions and discovery, and we really see, do we have a real threat? Is this risk real? Is it something we really have to be worried about? At that point, we say, okay, now we consider triggering the trust because again, there's cost to triggering and now you have the foreign trust maintenance requirements. So all the downside of the foreign trust comes into play. So we don't want to do that willy-nilly any old time. But the benefit is that because we have the trust in place, it completely changes the negotiating tactics for the client well before triggering the trust. So when I explain this to their attorney that's defending the underlying claim, whether it's a discrimination claim or a partnership dispute or a car accident where there's excess judgment potential, whatever it is, that attorney is relieved to know that they have a backup plan. And so they can be much more aggressive. They can, in some cases, we even reveal that their asset protection exists because that changes their financial calculation as to what they can collect. So it's extremely helpful, even if even if we don't ever have to actually trigger the trust and use the plan.
That's great. Well, Doug, so next steps, if, some of my clients, if I sit down, we have this conversation, what's kind of the next steps if they want to pursue this or, have that follow-up conversation?
Yeah, the next step would really be to have a call with me and just do an analysis. That's like a 45-minute call where we just talk about their assets, their risk, what their business is, what in their life could create the risk, and really get a sense of their risk tolerance as well. How much risk can they handle? Got some clients that can handle a lot of risk. I mean, ridiculous amount of risk, and other clients that really are averse. They really need to be protected. That's a huge driving. You see it in your investment profile, right? Some clients are like, hey, futures, let's go all the way, riskiest stuff. And some clients are bonds. We want it. So it's the same here. But what do we do in that analysis is I give you a real clear idea of what's already protected, because oftentimes there's some things that are already excluded and protected under federal law or state law, and what's not. And for the things that aren't protected, I give you a plan. What can you do to protect those things, and a really clear idea and a roadmap. And then from there, if you want to do it, they can work directly with me, and I can help put it in place.
Well, that's great, Doug. Well, I want to thank you, and for taking the time to walk through this with us, and I appreciate your time. And yeah.
I hope this is helpful, and I hope everybody learns something. And I always say to my clients, remember, it's your money. Act like it's your money. Thanks, Ryan.
Thank you again for your time, and stay tuned for our next videos. Bye, Doug.